When you hire a lawyer to handle a major business deal, you tell them everything. The price, the timeline, the companies involved, the vulnerabilities, the strategy, all of it, in confidence. That confidentiality is not just a courtesy. It is the legal and ethical foundation of the entire legal profession. Without it, nothing works. Nicolo Nuravchan was a corporate lawyer at 3 of the most prestigious law firms in the world. He went to Yale Law School. He was trusted with some of the most sensitive deals in American business, and for a decade, he was selling his clients' secrets. On May 7, 2026, the U.S. Department of Justice and the Securities and Exchange Commission announced charges against 30 people in one of the largest insider trading cases in recent history. This is how it worked, and this is why it matters. Welcome to Compliance Edge, where we break down the biggest fraud cases, corporate failures, and compliance stories that affect all of us. Let's get into it. To understand what happened here, it helps to understand what insider trading actually is and why it is illegal. When a public company is involved in a significant corporate event, a merger, an acquisition, a major contract, there is always a window of time between when the deal is agreed privately and when it is announced to the public. During that window, people who know about the deal, insiders, have an enormous advantage in the stock market. If you know Company A is about to acquire Company B at a 40% premium to its current share price, you could buy shares in Company B today and make a guaranteed profit the moment the deal is announced. This is insider trading. It is illegal because it is fundamentally unfair. It allows people with privileged access to information to profit at the expense of ordinary investors who don't have that access. It undermines confidence in financial markets, and it is a direct violation of the fiduciary duties that professionals owe to their clients. The law is clear, the penalties are serious, and the people who do it know exactly what they are doing. Nicolo Nuravchan graduated from Yale Law School and built a career at 3 of the most respected law firms in the United States: Sidley Austin, Latham & Watkins, and Goodwin Procter. These are firms that handle some of the largest and most complex corporate transactions in the world. As an M&A attorney, mergers and acquisitions, Nuravchan had access to highly confidential information about pending deals. When a company is about to be bought or sold, the lawyers working on the transaction see everything before anyone else does. Between 2018 and 2024, Nuravchan used that access to build a criminal enterprise. The scheme worked like this. Nuravchan would identify upcoming deals involving his clients, access confidential materials about those deals, and tip the information to a network of traders, led by his partner Robert Yadgaroff. Those traders would buy shares in the target companies before the deals were announced. When the announcements went public and the share prices jumped, they would sell, pocketing the difference. The profits were shared. Nuravchan received a cut. The scheme expanded. A second corporate lawyer was recruited to do the same, accessing client files, extracting deal information, feeding it into the network. In total, the scheme targeted nearly 30 separate M&A transactions involving public companies. One example, in 2022, while Nuravchan was on leave from Goodwin Procter, which was advising iRobot, he accessed the firm's document management system remotely and viewed confidential materials about Amazon's proposal to acquire iRobot. That information went to the trading network. The scheme ran for a decade, across multiple law firms, across dozens of deals, generating tens of millions of dollars in illicit profits. 2 of the defendants are currently fugitives, one in Russia, one in Israel. What makes this case particularly significant from a compliance perspective is not just the scale of the fraud, it is where it happened. Law firms are, in theory, among the most compliance-conscious institutions in professional life. They are subject to strict professional responsibility rules. They have ethical obligations that are codified in bar association codes of conduct. Confidentiality is not just a policy. It is a fundamental duty that every licensed attorney swears to uphold. And yet a lawyer at 3 top firms, across nearly a decade, was systematically accessing client files and selling the contents to traders. This raises serious questions about internal controls at law firms. How was Norafshan able to access confidential deal materials while on leave from Goodwin Procter? What monitoring systems were in place, and why didn't they catch unusual access patterns? When a lawyer who is not actively working on a matter accesses that matter's files, that should trigger an alert. In financial institutions, this kind of behavior would, or should, be caught by information barrier systems, sometimes called Chinese walls, which restrict access to sensitive information based on who is working on a deal. Law firms have analogous systems. In this case, they failed. The DOJ and SEC's ability to bring this case suggests that the patterns were eventually visible in trading data. Regulators can identify suspicious trading activity around M&A announcements, unusually timed purchases, positions that consistently appear just before deals are made public. That analysis led investigators back to the source, but it took 10 years. 30 people have been charged. 19 were arrested. 2 are fugitives. The charges include securities fraud, wire fraud, and conspiracy. The penalties can include decades in federal prison and the forfeiture of all illicit profits. For Norafshan, the consequences extend beyond criminal charges. His legal career is over. The bar associations of the states where he was licensed will pursue disbarment proceedings. The firms he worked for face reputational questions about their internal controls, though as victims of the scheme, they are not targets of the prosecution. For the broader legal profession, this case is a reminder that insider trading rings can operate inside the most trusted institutions, and that trust alone is not a compliance control. The clients who hired Nicolo Norafshan trusted him with their most sensitive information. That trust was the foundation of every fee they paid, every instruction they gave, and every decision they made in his presence. He treated that trust as inventory. The compliance lesson here is not complicated. Access to sensitive information must be controlled, monitored, and audited, regardless of how trusted the person holding that access appears to be. In the legal profession, in finance, in any institution that handles material non-public information, the systems that protect that information are only as strong as the controls that enforce them. 10 years, 30 defendants, tens of millions of dollars. This is Compliance Edge. Subscribe for weekly videos covering the fraud cases, regulatory failures, and corporate scandals that shape the world we live in. See you in the next one.